magnanimous and look at the whole process. On page 79, the court has said that the scene has been altered, which is a very grave finding prior to judgment. Coming suo motu, it would give an impression that the accused has already been convicted.
Yes.
And same on page 79, without an application making an order that the Kibera Court Community Service Order offenders should be cleaning up the scene of crime. Your Ladyship, the dilemma in this matter is this, that the scene of crime, which was the house of the accused, she lived in there. After the first trial, and Nolle was entered, the accused went there again, and then the scene of crime in this case has been alluded to.
Yes.
The scene of crime being visited by offenders under the community service offenders has its own legal complications. And this was an order made suo motu.
Yes.
So, Your Ladyship, on that is the position I am taking, and I will now refer you to some authorities, if I may.
Yes, Counsel. Do you have the list of authorities? So you just tell me if you go to the list of authorities, authority number 1, authority number 3, and then you can highlight the most relevant parts to the court.
Very well. Very, very quickly, because you have a list of authorities.
Yes, I have your bundle right here. Yes. So you just need to refer me to the page.
Your Ladyship, on page 1, I am referring to the constitutional provisions where state officers are obligated to perform their duty the way they should, and I will not allude to more than that.
Yes.
And these rights are not limited over to the constitutional provisions have been outlined very clearly. In exercising the powers of the DPP, the 157.11 Article 157 says, in exercising the powers conferred by this article, the Director of the Public Prosecution shall have regard to the public interest, the interests of the administration of justice, and the need to prevent and avoid abuse of the legal process. I underline the words avoid abuse of the legal process. Your Ladyship, I, at the very outset, stated the aspects of impartiality. I have no reservation in saying that Your Ladyship is totally impartial, but the introduction of various evidential documents without following the Evidence Act has resulted in Your Ladyship being privy to those pieces of evidence which you should not have been made aware. I have alluded to on page to the authority on section 150 and other sections of the Criminal Procedure Code. I have alluded to the Probation of Offenders Act. Your Ladyship, I can say that you will please look at the authorities which I have quoted and which I have submitted in its entirety, and no doubt you will look at it. Your Ladyship, there are a few matters which I need to reply in respect of the replying affidavit of the respondent. Your Ladyship, there has been made they made a reference to the Court of Appeal proceedings. Your Ladyship, those proceedings do not impact this application. That application pertains to bail in the Court of Appeal, not the trial. That reference is extraneous, as is the application for the notice of motion, which was apparently filed on 7th of January.
Yes.
I have this morning been given a list of authorities by the prosecution, which was filed late last evening at almost 7 o'clock. I have hardly had the time to look at the authorities. But I desire to comment on one or two important factors. They have given authorities for the recusal of the judge. Our application is not for recusal. It is for a mistrial and an order for nullity. Your Ladyship, in winding up my submissions, I wish to state that the proceedings as recorded by your Ladyship speak for themselves. And a microscopic reading of the proceeding shows a massive amount of procedural and evidential defects, which cannot be cured. And the only remedy, in my humble submission, in this matter is for the trial to start de novo.
Yes.
That is all, Your Ladyship.
Thank you. Thank you very much, Counsel. It's a pleasure seeing you appear before me. That is the very first time you have appeared before me. but I've always seen you elsewhere. I really, really want to apologize to the rest of the team. I am, Mr. Moda, I don't know how long you are going to take, because then I am in charge of the station. We are expecting some guests. If you promise me that you will take, what is the time? You will take very, very short time. It is 10:33. I have to rise by 11. Can we hack, Mr. Monda? Do you think you can make it?
Yes,
Thank
let
you.
me try to, my lady, so that we can move forward on this matter.
Okay, thank you.
Yes, my lady, my submission is very clear. Council wants you to recluse yourself from this matter, because one of the grounds is that this matter should be taken over. Oh, sorry.
Yeah.
Sorry.
Yes.
This matter should be referred to the presiding judge to appoint another judge.
Yes.
My lady, our humble submission is this. The defense is now waking up to the fact that they had a bad strategy. And are now looking for ways to blame the court and the prosecution for mistakes of their own making. We have a duty to tell the court the truth. And I will begin with a point my learned senior counsel friend says is most critical. This is regarding your rulings. My lady, we have filed our replying affidavit sworn by Sarah Ogweno on the 29th of December, 2025, and filed in court.
Yes.
My lady, attached to that affidavit is the notice of motion filed by the counsel representing the applicant, Mr. Sin Gitau, and an affidavit sworn by the accused person. In that affidavit, Your Honor, one of the issues we are challenging is your ruling denying the applicant accused person bail.
Yes.
And I will draw your attention to page 2, paragraph 5.
Yes.
This is the heading, 5A, on the issue that the applicant had intimidated witnesses.
Yes.
B, I believe you'll read that, so I will not read it, on the issue that the applicant was a flight risk.
Yes.
C, on the issue that she had tampered with the scene.
Yes.
Learned senior counsel says that this has no bearing on this case. That is not our position. Our position is they have appealed against your decision, and therefore they cannot invite you again to make a determination on an issue they themselves have referred to the Court of Appeal. I must hasten to add that there is no affidavit rebutting the fact that these issues have been placed before the Court of Appeal. Our submission on that is that you have no jurisdiction. The matter is seized of the Court of Appeal, and therefore you have no jurisdiction to determine those issues before you.
Yes.
Let the Court of Appeal determine those issues.
Yes.
I will be shortly sharing with you the date, 11th of February. This year, this notice of motion before the Court of Appeal has been set down for hearing before a 3-judge bench, and notices issued to parties.
Yes.
My lady, if I may go back, the accused person was represented by very able counsels in this matter. In fact, if you recall, when the matter came before courts, we have attached the proceedings SO1. Mr. Maloba appeared together with Mr. Mureithi Mbati and Mingo for the accused.
Yes.
We took the view that mental assessment should be done first before plea is taken. My lady, the counsels on record vehemently opposed that position.
Yes.
And in your reasoned ruling, which we have attached at page 8, agreed with them. Now, my learned senior friend, Mr. Bauri, takes issue with the regard of the medical report. That is the mental assessment report. But my lady, I will draw your attention to page 9 of the proceedings we have attached in our replying affidavit, SO1, page 9 at the bottom. This is what Mr. Maloba says. They have sent me, I have seen it, I confirm it's authentic. This is counsel for the accused person. Your Honor, what do you do? You rescind your earlier order to escort the accused person to Mbagathi, plea to be taken now. That is at page 10. My lady, where is the irregularity there? Where is the prejudice?
Yes.
Another point I would like to raise at page 9.
Sorry?
Page 9, still page 9 of the proceedings we
Yes.
have attached. This is what the court says. I take judicial notice of the fact that this is a case of public interest, and therefore I expect the investigating officer to present to this court the mental assessment report not later than 31st January 2025. We must read context into this matter. In fact, you're working to assist and expedite the process. Why should you be blamed for that? Lastly, I make reference to page 8, where Mr. Maloba, on behalf of the accused person, is addressing the court as follows. At the very bottom, Mr. Maloba, I make reference to the ruling. You have made a finding that the accused person is fit as the previous mental assessment report in case number 60 of 2019. You have made the ruling that the accused can undergo a further assessment. We now request that accused takes plea. Those are not the words of the prosecutor. Those are not the words of the court. That is the accused person who is ably represented by counsel. In fact, Your Honor, we have skimmed through the affidavit. There is no iota of complaint against the manner in which Mr. Maloba proceeded with the case. So that, Your Honor, if counsel proceeded in a manner the current counsels on record feel was irregular, we are beyond that, Your Honor. We are past that. We cannot go back. And it is our view that this application is intended to cure that. The mistakes that counsel made, and therefore they would like to cure those mistakes. Your Honor, nowadays, documents are filed on the judiciary e-platform. In fact, a plea will not be registered if documents are not filed on the e-platform in order to retrieve a registration number. I submit we must groove with the times. We are no longer in that era where documents would just be served manually. They are served both manually and on the e-platform. Apart from that, Your Honor, we have attached SO2, disclosure checklist. Your Honor, the disclosure checklist, SO2, was signed by Mr. Maloba. Mr. Maloba made no comments on the documents that he had received. In fact, pursuant to your directions, Mr. Maloba actually attended our office. And was handed over all the documents in possession of the prosecution. In fact, prior to the trial, Your Honor, Mr. Maloba did not make any reference to the fact that he was not given all the documentary exhibits and statements so that he would mount a defense for the accused person, the applicant in this case. So that, Your Honor, Mr. Maloba properly and ably handled the matter on behalf of the accused person. Your Honor, I will not belabor the points. The counsel were in court, saw Mr. Pascal Buana being sworn before you. At page 50 of our record, he was cross-examined by Mr. Maloba. Then Mr. Maloba made this following application. Mr. Maloba, I want her to testify. That is the accused person applicant in this matter. The accused person was sworn, testified on oath. The accused person was never told to testify via an affidavit. She was cross-examined. Next was Sergeant Nora Mutuku, page 51. Same thing again, Mr. Maloba chose not to cross-examine her. So that, Your Honor, in our humble view, you properly dealt with the matter and came to the correct finding. Regarding the scene visit, Your Honor, we took that during the pre-trial conference that we had. The prosecution from the onset was clear that we would visit the scene. And in fact, we were clear again that we would begin with the protected witnesses. Your Honor, Mr. Maloba made no objection to that application. In fact, he was also given an opportunity to go to the scene prior. Witnesses were sworn and cross-examined. In fact, 3 witnesses, my lady. all cross-examined by Mr. Maloba. So that, in a nutshell, Your Honor, all rulings that you made in this matter, you gave an opportunity to both the prosecution and the defense to make presentation and therefore made your decision. In fact, those submissions, I will not belabor, my lady, page 74, 75, 76, 77, before you made the orders of preservation. So all parties were heard. This brings me to the next aspect, Your Honor, which is the application notice of motion, which my learned friend properly referred to. That is the one we had filed SO6. Attached to that affidavit is, attached to the application is the affidavit sworn by Patrick Macau on the 7th of February 2025. My lady, nowadays it's very easy to check on the platform, CTS. We uploaded this document on 8th of February 2025. By their very nature, these are ex parte orders. So we submit that in our view, it is just a typo. Instead of saying February, it was written in January. But that can be confirmed nowadays very easily through the CTS system. The learned senior counsel has made reference to mistrial and nullity and expunging of documents. I would like to refer to section 382 of the Criminal Procedure Code.
Section
382
yes.
of the Criminal Procedure Code. I'll just read, subject to provisions here in before contained, no sentence, order passed by a court of competent jurisdiction shall be reversed or altered on appeal or revision on account of an omission, irregularity in the complaint, summons, warrant, charge, proclamation, order, judgment, or other proceedings, or during trial or in an inquiry otherwise than this court, unless the error, omission, or irregularity has occasioned a failure of justice. All through, Your Honor, all through the submissions by senior counsel, there has been no demonstration of prejudice. In fact, the attempt was that given the manner in which you are proceeding, it might be deemed to be impartial. No, Your Honor, it is either you are impartial or not. Do they have a remedy? Yes. The remedy is not for you to excuse yourself from the matter. The remedy is for them to approach the Court of Appeal and reverse those orders or rulings. It is therefore our humble submission that there is no basis for you to refer this matter to another judge to continue handling it. In any event, they have expressed confidence in you. So our submission is there is no basis for you to hand over this file to any other judicial officer. Any ruling or decision by this court which the applicant feels that is not correct, they are at liberty to move to the Court of Appeal and proceed. Lastly, Your Honor, I'll refer you to the decisions. That's our list of authorities. As a state officer, as correctly pointed out by senior counsel, you have a code of conduct. And we have aptly captured that in our list of authorities. Article 221, sub-article 1 and 2 of the Judicial Service Code of Conduct and Ethics. This is now to you, Your Honor, not anybody else. And this is what the Code of Conduct says. A judge may recuse himself or herself in any proceedings in which her impartiality might be reasonably questioned, where the judge, A, because here they're talking about impartiality, is a party to the proceedings. You are not a party to these proceedings. B, was a material witness in the matter in controversy. You are not. C, has personal knowledge of disputed evidentiary facts containing the proceedings. You don't have that knowledge, Your Honor. Has actual bias or prejudice concerning a party. None whatsoever. In fact, your first ruling was in favor of the applicant in this matter. Personal interest or relationship with a person who has a personal interest in the outcome of this matter. None whatsoever. In fact, the applicant has not even placed that material on record. Had previously acted as a counsel for a party in the same matter. You have never acted for the applicant. So that, Your Honor, we are saying all this listed, including G, which says is precluded from hearing the matter on account of any other sufficient reason. We see no reason at all. Forget it even about being sufficient. We see no reason at all. Or a member of the judge's family has economic, there's none whatsoever. Okay? And we are saying, Your Honor, where a party brings an issue of impartiality to a court, it must be recorded in writing. We cannot come here and say there are prosecutorial improprieties, there are judicial improprieties. What are these? How is a judge supposed to make a decision when there is no proper application before the judge? All you are being told is that because you're making decisions or taking a procedure which in their view is not proper, you should then exclude yourself from the matter. That is not. We say that you must present evidence and that also you must demonstrate. Which brings me to the authority, Your Honor, at page 3, direct line assurance. The court reaffirmed that the judge's prior unfavorable conditions against a party do not constitute evidence of bias or justify request for reclusal. So that we are saying, if they are complaining about your decisions, they are complaining about the procedure, they have an avenue to the Court of Appeal. It cannot be that you should now stop handling this matter and transfer it to another judge. No. We have absolute confidence in you, Your Honor. You have treated parties with extreme decency and courtesy in this matter. In fact, all the way through, no counsel in this matter has ever raised any complaint specifically against you. The affidavit that is even being sworn by the accused person, she had an opportunity to raise these issues through Advocate Maloba. That has never been raised, Your Honor. That's why we're a bit taken back. So that as we conclude, Your Honor, we are saying that there is no basis for this application. In fact, Your Honor, as I wind up,
Yes,
normally
please.
when you conclude, you even invite the accused person herself to say anything. She has never spoken to the fact that she is dissatisfied in the manner you have been conducting the trial, including the rulings that are delivered in her presence. We dare say she has actively participated in the matter. So that, Your Honor, in our humble submission, this application is misplaced. We urge you to dismiss it and prioritize its hearing. And to borrow the words of Mr. Maloba counsel, the matter has taken long. So we therefore must prioritize. Thank you.
So looking at the Joseph Lendrix Waswa, probably have the victims, if they want to make comment, they can without usurping prosecutorial powers. Victims counsel, if there's anything that touches on the victims that has been made, did you make any affidavits for the victim? Mr. Wakwa, Mr. Wakwa, Ngakima.
My lady, perhaps I appear together with Mr. Wakima.
Yes.
Just a brief, we had just made a grounds in opposition.
Remember, in your submissions, do not usurp Mr. Monda's powers. Speak for the victims strictly. You proceed.
Yes, my lady.
Yes.
And actually, we are very brief. And I must state at the very beginning that we associate with the prosecution's position in this matter. Our main bone of contention is the tactic of the accused to delay this matter. the only interest of the victims in these proceedings is to see to it that justice is done and to all the parties. And with that, it calls that no party should have latitude to choose own judicial officer or to decide which judicial officer should preside or not preside over a trial. So in this, we are just saying that this application, although disguised as an application for declaration of nullity, it is in essence a recusal application. Nothing has been cited to impugn the conduct of your leadership or the court in how this matter has proceeded. Secondly, my lady,
we
wish
lost
to
counsel, or can other advocates hear me? It is our internet that has fluctuated. Everyone is at
Yes,
statue.
yes. We can hear you.
We can hear you, my lady.
We lost you,
Yes.
counsel.
Okay.
Maybe, my lady,
Okay.
before we...
Maybe at what point?
We can hear you.
We have just that the application is disguised as a declaration of nullity, and yet it's an application for recusal.
Yes. Simply put, is an application for recusal. And nothing has been brought forth to impugn the conduct of the judicial officer, that is your leadership, or the court itself, such that the Judicial Service Act, no part of it has been...
Boundaries. Stick to the victims. That is for Mr.
Yes.
Monda. I will leave. I leave it at that. Yes.
Yes. My lady,
Father,
I just have something to add on what my colleague Mr. Tumo has said. Is that it is true, and it is the position of the victims, some of whom have camped here due to the fact that if, or per record, we had taken dates for hearing. It is our position, my lady, that this seems to be a delaying tactic to delay this matter. And I join Mr. Monda to say that this matter has taken too long. My lady, you have been kind enough to give us a series of dates, which we have now lost due to this application, which Mr. Tumu has put correctly, that it is an application for recusal which has been laced with issues of procedure, which procedure we all participated in. Therefore, our prayer, my lady, is that it is an attempt too by the defense to have a second bite on the cherry. Yet the trial was properly handled. On behalf of the victims, we are comfortable with how the trial was conducted. Therefore, we ask you to find that we proceed with this matter and find justice for the victims. That will be all, my lady.
Let me see the time. What is the time? Okay. Council Bowry, You have a right to reply, but may I know how long you are going to take?
I'll take 5 minutes or less.
Oh, thank you. Thank you. That will be kind of you. Please proceed.
Your Ladyship, in response, I want to submit on matters of jurisdiction. Article 165 3A gives you unlimited original jurisdiction in criminal and civil matters. Your jurisdiction to handle that trial is unlimited. So the contention that your Ladyship does not have jurisdiction does not hold. Just because an appeal has been filed in respect of the bail matter does not render the court's jurisdiction as not being there. The Court of Appeal application does not divest you from hearing the trial. And we are in this application questioning the future of the trial because of what we have shown to be factual, procedural, and evidential defects. Your Ladyship, the contention is that the accused counsel did not object. That does not validate grave procedural and evidential defects. For example, the matter of a witness being sworn or not sworn, the counsel would not have been privy. It has been suggested that the documents need to be filed on the portal at the commencement of the trial. With utmost respect, that is a preposterous contention. The only document which the prosecution has to file is the charge sheet, not a so-called bundle of documents or a so-called committal documents or a list of checklist of witnesses and so on so forth. The court is not to be privy to what transpires between the accused and the prosecution. Your Ladyship, we have shown that there were both prosecutorial and judicial acts which have impacted on the trial, the procedure of the trial, and which we say under the Constitution, they are not likely to get a fair trial. And it cannot be remedied by Section 382 or any other law. I reiterate again that this is not a recusal application at all. Looking at all the issues which we have raised, we have shown that this application is merited. Indeed, if we were not to take this stand and to wait and continue with the trial as things stand would mean that we are virtually condoning the defects which have, having the court having all the committal documents, is it a defect or not a defect? Those are the type of things which are so fundamental to the adversarial systems which exist in our country. That is all. I would want my learned friend, Mr. James Singh, to respond as well briefly, because he has been in the matter since inception.
Mr. James Singh, how many minutes?
My lady, just the same 5 minutes that my learned friend too.
Go on, go ahead.
Okay. So, my lady, in the first instance, the issue of appointing a new judge is not correct. We're not forum shopping. It is for this reason we have asked the presiding judge to appoint someone else. We do not know who the presiding judge will appoint, neither do we care. We will appear before that judge. Secondly, my lady, both the court and the prosecution are officers of this court. That duty also goes, so they have a duty to ensure that the court proceeds without an abuse of the court process. It behoves them to be
I'm
custodian.
recording, counsel.
Sorry.
The court proceeds.
I'm sorry, my lady.
You have the prosecution. Let me
yeah,
recap
sorry,
that. They have a duty to ensure that the court proceeds
without an abuse of the court process. It behoves them to be custodians of the law. My lady, if there is an excess on the part of the DPP, the court must step in. The rules of procedure are not bound to the parties. The gatekeeper at all instances is the court.
I cannot hear you, counsel. You are too fast. You're reading and you're too fast. I may lose something and you will say judge did not capture. I am at, if there is excess on the part of the DPP, the court must stem it. That is where I am at.
Yeah, the court must step in.
Yes.
The rules of procedure, my lady,
yes,
are not bound or designed specifically for the parties. It is this court, the judge, that is the gatekeeper. And where there's transgression of whatever type that goes against those rules, it behoves the judge to step in. We're being told that these proceedings, my lady, are similar to those before the Court of Appeal. The matter before the Court of Appeal is specific to that court. You cannot be asked to make a determination on a matter that is before the Court of Appeal. The issues are completely different. Before the Court of Appeal, we have the denial of bail, which is a constitutional right. The application which is being argued before you is for recusal. Granted, my lady, there may be an overlap, that the overlap of facts, but the issues of law are completely different. The issues of law will be based on facts. So if there's a misinterpretation, if the facts show that there was an abuse of the court process or misapplication of the law, of course, you will ground them on that. You're not going to argue the matter as a simple issue of procedure. The long and the short, my lord, my lady, is that the matter before the Court of Appeal is constitutional. The matter that is on record is distinct from that. What we're saying is that the way in which this matter has proceeded thus far has various shortcomings. And in particular,
the way this matter has proceeded has done what, pardon?
It has several shortcomings. And in particular, the issue of uploading of the statements and
No,
evidence.
you can't repeat what he said because
Yes,
you
my
are
lady.
only, yes, you are
Yes,
just emphasize, but do not repeat kindly.
yes.
There,
So
the issue of uploading,
of statements
yeah,
which
yes.
you have referred to and made rulings on is what makes this a mistrial.
Which have been,
On which you have seen and on which you have
okay.
made, which you have seen and which you have made rulings on is what make this matter a mistrial. My lady, we're being told that Mr. Pascal Buana was sworn. Where is it on the record? This is a court of record. When I filed the bundle before the Court of Appeal, will the DPP come and say, as he did this morning, that Mr. Buana was called and sworn in? He cannot, because there is no provision for that in the Court of Appeal. The Court of Appeal will make the determination on what is before you. Likewise, my lady, you will make a determination by virtue of what you copied. He cannot come in and say, as he did again, that there is a typo in the heading. It is not. The record shows that there is a case number. We're not going to the portal or anything. We are going by the record. And he cannot come in and say that Section 183 of the Civil Procedure Act does not apply. The Criminal Procedure Act applies where there's a substantial failure of justice. And it is of a submission, as has been elaborated by Mr. Bowery, that there has been a substantive failure of justice in this case. It has been suggested that we are impugning your conduct, my lady. We are not. We reiterate that you are, as far as we're concerned, impartial. But this, my lady, does not mean that they're not material irregularities. Those are what make this a mistrial. And the two can coexist side by side. You're obviously impartial, and we agree with that. But when we look at the record and we see the manner in which the trial has been conducted, there's substantive failure, and this is what we give grounds for a mistrial. In conclusion, my lady, of course, the rights of the victim are important, but those of the accused in a criminal matter, especially where the charges and consequences are grave, such as this one, the rights of that accused person are paramount. So whether there is a delay, unfortunately unintended, you must deal with the issue in question to make sure that what we have is a fair trial and seen to be a fair trial. That is all, my lady.
Thank you very much. All right, I will try my very level best to deliver this judgment. I will try my very level best, ruling rather. On the 11th of February, I will try to push myself. If I am not able, because next week I'll be handling the Shakahola case in Mombasa, I'll carry the file. But if I am overwhelmed, I will do an email through case progression that I may not be able to deliver, in which case I'll just mention the matter and give you another date. But I will really give it my level best, and have a good day. Allow me to kindly.
Your ladyship, may I just seek a clarification? The matter is listed for the month of February.
Which matter? This one? We have hearings in February?
Yes,
I think no. We had given you dates, but you did not take the dates up. I remember when we mentioned the matter, you said you had you needed time to read the file, you needed time to make an application. So we
Your
took out
Ladyship,
those dates.
my record shows that we had fixed this date from 9th to 13th.
Yes, I did. I did, but in view of the fact that there is this application, then we have to deal with the application, because then I cannot hear the matter
Much
when the defense do not want me to hear the matter. I have to deal with that issue first, and that is why I'm saying I will, yes. I may not be able to do the ruling before you can see the bundle. Look at yours. In addition to what you have filed, it is very bulky, voluminous. That's why I'm trying to see whether I can manage to do the ruling by 11th. I would be lying to you if I tell you that I'll be able to work on it tomorrow and Sunday. Sunday, I'm traveling to Mombasa for the Shakahola case. It is equally a very heavy case. So it means I can only write this ruling every night when I get time. And that's why I'm saying, let me try and see if within 1 week on 11th, I'll be able to deliver. If I am not able, I will communicate in writing, then we will bring up the matter. Have a lovely day. I'm so sorry, I have to go. It is my station and I have guests, the whole country. I think the entire of the judiciary, I'm the only one in court. We have an open day and I did not want to adjourn your matter.
Much obliged, we appreciate